My name's Andy Holton. I work for SWAT, and it's my pleasure to talk to you now about the 2017 money laundering regulations and what's changed. Well, to give them their full title, the Money Laundering, Terrorist Financing and Transfer of Funds (brackets Information on the Payer) close brackets regulations 2017 were laid before Parliament on the 22nd of June, and they came into force on the 26th of June. There had been some speculation as to whether the regulations would make an appearance and whether the general election would mean that they would actually miss the deadline, but they are now in force and were just inside the deadline. The information on the payer element of the regulations is actually a separate EU regulation, which I think the government included here for simplicity, and this part of the regulations has no real impact on accountants, so I will simply refer to the Money Laundering Regulations 2017 or just the Money Laundering Regulations. As far as accountants are concerned, the scope of the regulations hasn't changed very much, although there have been some changes that will affect your clients. So in particular, letting agency work has not been brought into the regulations as was originally expected. However, letting agents that are also estate agents will continue to be regulated for any estate agency work that they might do. And that's of course buying and selling property. Casinos remain the only part of the gambling sector that is regulated, and this includes actual and online casinos. Another important change is that the threshold for registration with HMRC as a high value dealer has fallen from €15,000 to €10,000. So this may affect some of your clients, such as antique shops, art galleries, motor dealerships or the like, and some of those may now need to register or alternatively look at changing their procedures. Let's look at some of the guidance that's available in relation to the new regulations, as some of this has already been published. The Joint Money Laundering Steering Group guidance has been published. This guidance is aimed primarily at the financial services sector, but part 1 is relevant to all in the regulated sector, and our own CCAB guidance, which I'll come on to in a moment, actually makes reference to this guidance as the overarching guidance we should follow. You can access the Joint Money Laundering Steering Group guidance by Googling the Joint Money Laundering Steering Group. HMRC have also updated their guidance for those businesses that they supervise, and this includes trust and company service providers and high value dealers. Companies House have amended their guidance for people with significant control, and then the FCA has also published guidance on the treatment of politically exposed persons for anti-money laundering purposes, and also produced draft updated guidance for auditors. Unfortunately, what is missing at the moment is the CCAB guidance. This is guidance published jointly by the Chartered Institutes in England and Wales, Scotland and Ireland, and also the Association and SIPFA. And this is the relevant guidance for us as accountants. And the current version has been approved as relevant guidance for the accountancy sector by the Treasury. So obviously it's important that we have this guidance updated for the 2017 regulations. The updated version will again require Treasury approval, but we were hoping that a draft version of the draft guidance might have been published by now. Unfortunately, we are still waiting for that. But let's go back to the regulations and look at some of the changes there. So firstly, some changes to definitions and those that might have an impact on your client. So the meaning of a business relationship. A business relationship continues to be a professional or commercial relationship between a relevant person and a client that arises out of the business of the relevant person, so that in your case is you as the accountant, and is expected to have an element of duration. So that hasn't changed, but what has been added that is company formation has been specifically added, that if even if it's the only service provided for a client, it is to be treated as a business relationship. And that means that client due diligence is required. Then a further change in relation to estate agents is that they are treated as entering into a business relationship with both the buyer and the seller at the point that a purchase offer is accepted by the seller. This means that client due diligence will be required on the buyer as well as the seller. So an important change for any estate agent clients. Moving on to look at beneficial ownership, whilst some of the words have changed in relation to beneficial ownership, there's no real difference in the definition of a beneficial owner of a company or an LLP, although there is now reference to the conditions to be people with significant control as set out in the schedules to the Companies Act. But an important area of change is in respect of politically exposed people, or PEPs. The key requirements remain unchanged in that a person is a PEP if they are entrusted with a prominent public function in a high-ranking position. Middle-ranking and more junior officials do not qualify as PEPs. But what has changed is that there is no longer a reference to jurisdictions outside the UK. So we now need to consider UK PEPs. And we also need to consider the close family of a PEP. So that is a partner, child or parent, or a close business associate, such as a person whom the PEP jointly owns a business with. What constitutes a PEP is set out in the regulations, and this includes heads of state, heads of government, ministers and deputy or assistant ministers, members of parliaments or similar legislative bodies, members of the governing bodies of political parties, members of the Supreme Court or constitutional courts. Now we need to wait for the CCAB guidance to be certain how this will be applied in the accountancy sector. However, the FCA guidance that has been published does give us a good indication of how it will work. So for example, under the FCA guidance, local government officers within the UK would not be captured as PEPs, although their overseas equivalents might be. Political parties would only include those that have national representation in Parliament or equivalent. So political parties without an MP, for example, would not be considered as PEPs under this interpretation of the guidance. Only Supreme Court judges will be considered PEPs in the UK, not appeal or High Court judges. International organisations means the like of the UN or NATO. It doesn't extend to things like international sporting federations or international charities. Another important area where we have changes is to do with risk assessment. The AML regime has always been one based on risk, and what has changed in the 2017 regulations is that risk assessment is more prominent at a number of different levels. And this is certainly one area where more detail and documentation on your files will be required. We will be reviewing and updating the risk assessment procedures at a firm and client level in the manuals and issuing these in draft in advance of the full manual updates. This is because the full manual updates cannot be completed until after publication of the final CCAB guidance. So under the regulations, risk assessment is actually required at 4 levels. Firstly, HM Treasury is required to update the UK National Risk Assessment by the 26th of June 2018. This is a risk assessment to assess and mitigate the risks of money laundering and terrorist financing affecting the UK. And the accountancy sector was considered high risk in the 2015 risk assessment. Then secondly, the AML supervisory bodies, such as the Institute or the Association, are required to assess the risk of those that they regulate of money laundering and terrorist financing, both domestically and overseas. And that risk assessment by these supervisory bodies must take account of the national risk assessment. Then thirdly, as previously, firms must prepare a firm level risk assessment considering the risk that the firm or their clients may be involved in money laundering or terrorist financing. And in setting the firm level risk assessment, they should take into account the supervisory body risk assessment, as well as considering the nature of their clients, the geographical areas in which they operate, and the services that the firm provides. And this risk assessment needs to be documented. It can be commensurate with the size and nature of the business, so obviously less detailed documentation for smaller firms compared to larger firms. And then finally, we have a client level risk assessment, and that is set in the context of the firm's firm level risk assessment. So quite a lot of change in relation to risk assessment. But let's move on and look at client due diligence. There has been no change to the circumstances where due diligence procedures are required. And the customer due diligence procedures that we need to follow remain broadly the same, in that we've got to verify the identity of your customer or client, as we call them, assess and obtain information about the purpose and intended nature of the business relationship, identify who the beneficial owners of your client are. So verification of identity and beneficial owners and ongoing monitoring of identity and transactions remain risk-based. So this should be based on your firm's overall risk assessment and the risk assessment carried out on that particular client. And the regulations specifically acknowledge that the procedures undertaken will vary from client to client because they are risk-based. However, we do still have an obligation to apply enhanced due diligence in certain circumstances, and there have also been some changes to enhanced due diligence itself. So whilst, as we've just noted, client due diligence is risk-driven, the regulations state that enhanced due diligence measures and enhanced ongoing monitoring should be applied in certain specific circumstances. These include in any case where there is a high risk assessment, in any business relationship or transaction with a person in a high risk third country, if the client is a PEP or a close family member of a PEP, or in any case where there are unusually large or complex transactions or unexpected patterns of transactions that don't appear to have any economic or legal purpose. So that may actually bring us back to the first point, because we would usually expect to see a high risk assessment in those circumstances. That's not a definitive list, but those are some of the main indicators of where we would expect to see high risk. But then what constitutes enhanced due diligence has also changed. This is no longer a fixed response, but a range of options that include additional independent verification of information that we obtain as part of the due diligence process. It might include obtaining more detailed information about the financial position of your client or any other parties that are involved. It may include taking further steps to be satisfied that a transaction is consistent with what you'd expect to see. Or it could be increased monitoring of the business relationship and transactions. The new regulations are also more prescriptive about factors to be taken into account in the risk assessment that leads to enhanced due diligence, but they don't provide a comprehensive list, and the regulations also note that one or two higher risk factors does not necessarily mean that you conclude the client is high risk and that you therefore need to apply enhanced due diligence. And we will obviously build these factors and the changes to enhanced due diligence into the risk assessment forms that we will be issuing in due course. Then finally, I'd like to talk about reliance on third parties. Under the old regulations, there was a specific list of bodies on who you could place reliance should you choose to do so, and should they give you permission in relation to conducting client due diligence. The regulations have changed, and reliance can now be placed on anyone within the regulated sector, and this includes those in other member states that are governed by the fourth directive. but as previously, your firm would remain liable should the other firm not apply the required measures. No reliance can be placed on information obtained from a country that is considered a high-risk third country, so I think no surprises there. But if you choose to rely on another party, you've got to immediately obtain from them all the information you need to for due diligence purposes. And you can do that either by obtaining agreement from them that they will provide immediately, or request on request copies of the relevant information, or you can provide or obtain certified copies of the evidence held. And obtaining certified copies is certainly the better option, as you then have the evidence on your own files. So this has been a quick review of the changes in the 2017 money laundering regulations, which I hope you have found useful. If you do require further information, then please visit the Mercia or SWAT websites, where there are various articles for you to look at. Thank you for your time.